And welcome back. And if you're joining us and you see that decision, that's correct. The grand jury has reached the decision. It has not been made public yet. What it is out of Ferguson, Missouri, we're now learning it will be released at 9 p.m. Eastern Time, 8 p.m. Central. They've decided whether or not here Officer Darren Wilson should face criminal charges in the shooting death of unarmed black teen Michael Brown. In a few minutes, we're going to hear from the Missouri Governor, Jay Nixon, for the latest on this in an effort to obviously preach calm to the community. Now, the grand jury, as we all know, consists of 12 people. Here's a look at the breakdown of this particular grand jury by both gender and race. The jury consists of 6 white men, 1 black man, 3 white women, and 2 black women. 9 votes are needed to indict here, and there are 4 different charges that Wilson is facing right now, including second-degree murder, second-degree manslaughter, which is defined as knowingly causing the death of another person and comes with a penalty of 10 to 30 years in prison. Voluntary manslaughter, defined as causing a death under the influence of sudden passion arising from adequate cause. And the charge also comes with a penalty of between 5 and 15 years behind bars. Involuntary manslaughter in the first degree, which can mean recklessly causing a death, penalty of up to 7 years. And finally, involuntary manslaughter in the second degree, which is defined as acting with criminal negligence to cause a death, and that comes with a maximum penalty of 4 years in prison. You all know pretty much the timeline of events here as you look through this. This has been going on since August, and that's when this first happened. Then we saw the grand jury began hearing evidence on August 20th, and then today, the decision has been reached. Let's bring in our 2 attorneys here for some perspective on this case. Bill Aronwald, former criminal defense attorney, former federal prosecutor, and also with Aronwald and Pickett. Mayo Bartlett, attorney and former chief of the Bias Crimes Unit, Westchester County DA's office, and also involved in a lot of civil rights cases right now as a defense attorney as well. All right. First off, it's been a long process. A lot of people thought drawn out process. But when you heard early this afternoon that the grand jury had reached a decision, did you think that we'd be waiting till 9 p.m. at night here for it to be finally released? No.
And the only thing I could think of is that the district attorney feels that whatever the decision is going to be, assuming it's going to have some reaction one way or the other, that it would be better to announce it later when a lot of people are already back in their homes and doing it in the middle of the day.
Mayo, to that end, explain what, I know there's not one way of doing it. What is the typical process in terms of who gets notified? I think the public's out there saying, oh, they decided they must know already. Everybody must know what's going on. That's why they did the state of emergency. Give the reality of how the process works when the family's notified, when the governor's notified, when the people on the ground are. How does that process go?
Well, that depends. It's very case specific, and it depends on the prosecutor's office. And sometimes they'll contact the family no matter what, even in cases that are not quote-unquote high-profile cases. Other times they don't contact the family at all. I tend to believe law enforcement probably is advised, and the governor would be advised if you think that there's going to be a cause where you may need to have the National Guard motivated, and that basically involved in the case, and that gives them an opportunity to plan. But lots of times nobody learns about it until the actual decision comes down from the grand jury. And most of the cases that are not high-profile cases don't take this long and may not be as fully presented as in this case.
Yeah, the important thing to understand is what is the mechanics of an indictment. An indictment voted by a grand jury does not become a court document until it's presented in court. And so, generally speaking, I mean, the indictment has to be presented during normal court hours. That's the normal course of events. Sometimes it can be sealed. So in this case, the indictment may very well have been filed earlier. It may have been sealed pending the public announcement of it. And one of the people that would be notified would be Officer Wilson's attorney, because either he's going to be summarily arrested if there is an indictment, or they're going to make arrangements for him to voluntarily appear in court for arraignment.
So in that way, don't you think it's in all likelihood we'll know before 9 o'clock that there'll be some reports about whether or not, in fact, he's been arrested or not here, or he's in custody right now, because one would think it's going to give you an indication as to whether or not they came back with an indictment on one of the 4 charges.
Occasionally, though, you wouldn't let the target know, because that gives that person an opportunity to flee. So if you don't want that person, if you think that they're a flight risk, you're not going to tell them. They're just going to get a knock on the door and they're going to get taken into custody.
I think some people will be looking out for Officer Wilson. He'd have a tough time running.
But you know, Richard, it would explain, it's one scenario for why the announcement came of a decision, but we don't know what it is yet. Under one scenario, as pointed out by somebody who's prosecuted these types of cases, they could be processing. Now, this is only speculation on my part. They could be processing Officer Wilson for an indictment. We don't know what count yet. That could be why. I tend to believe that it's more they're trying to prepare the community for a non-indictment and to ensure that violence is not ensured.
Just a quick timeline reminder, everybody. In about 4 minutes or so, at least it's scheduled at 6:30, Missouri Governor Jay Nixon, he'll be addressing, and we'll have that live for you. But let me ask you, if we could bring up, guys, and that's a live picture right now from where the governor's press conference is supposed to be held. If we could bring up, Ralph, in the meantime, the 4 different charges that they're looking at. And is it fair to say that the most important question that the grand jury had to answer is what was reasonable as it related to Officer Wilson? What was reasonable as it related to his action?
Well, in terms of the involuntary or voluntary manslaughter charges, yes. With respect to the murder charge, I mean, I think what the threshold issue is, before you even get to whether what Officer Wilson did was reasonable, is whether, and I guess it's included within that, is whether whatever he did, was he justified in acting the way he did under the circumstances and based upon anything that Michael Brown did. And I think if the grand jury were to find that whatever he did he was justified in doing, then the only fair result would be to no bill it. In other words, no charges would be filed.
But you know, Dominic's a big fan of saying you can get a grand jury to indict a ham
Of course
sandwich.
you can.
But Dominic's a terrible lawyer.
No, I'm actually a very good one without a law degree.
I'm curious, if there's no bill, if there's no indictment, is that an indication that prosecutors just didn't present enough of a case to get an indictment, or that it wasn't there? Is there any way to read into that?
No, but Mayo, we
hear?
do know, to Andrew's point, that again, for the general public, but I think the vast majority of cases, when the prosecutor goes before the grand jury, he or she is seeking an indictment on a particular charge. He's telling the grand jury, this is what I believe. This is what I believe you should come back with an indictment on. In this particular case, the prosecutor said, and he was upfront about it, he says, I'm going to lay out all the facts about the case. And then you, the grand jury, can decide for yourself if any of them seem to fit or not, but I'm going to lay out all the evidence for you, and I'm not going to take sides. There's people who argue that's the way the process should always work, but that's not typical, I think, right now, of usually how it works,
no,
right?
It's not. And it ought to, Bill and I were talking about that before, and we were discussing the fact that that's how it ought to work in every case. Every single person charged ought to be afforded a full hearing of everything, all the information, and that way a grand jury is not abused. Because what happens sometimes is it's more politically viable for a prosecutor to pin it on a grand jury. They indicted or they didn't indict. That way you don't have a problem with the police union. It's like, hey, we just put it all in there and the grand jury indicted. And also you can run for re-election without the community saying what'd you do. You say, well, we gave it to the grand jury. So what can happen is generally in cases the prosecutor does have a horse in the race. They believe that the suspect is the person who did it. That comes across in the instructions, but it also comes across more so in the way that you present the case, your facial expressions, the intonation of your voice, whether you're nodding in accordance with a witness when he or she speaks, or whether you're just kind of stoic. You can send lots of messages that don't appear on the transcript. But the other thing that's interesting about the 4 charges, the last charge would be the equivalent of a criminally negligent homicide in New York State. Mm-hmm. And what you're saying there is that it's almost a civil component, except as a criminal element. And you're saying that a person didn't act reasonably, but you're taking intent out of it. You're more or less saying that, you know, if the person had been more prudent, this didn't need to occur. Now, what sometimes happens is prosecutors go in and they only seek murder. And murder's a heck of a tough charge to pursue, because you're now saying,
Right.
oh, this officer intended to kill this person. That was his conscious motive.
If I could, Bill, again, you guys have done more of these, or forgotten more of these, I'll never know, but it's not like this jury was sequestered, okay? These 12 people had to go home every night. They saw what happened in August. They saw the rioting. They saw everything else. They've been hearing that, hey, they might release all the transcripts from the grand jury, and even the people in the grand jury. Now, whether they do or not is a different story. But this is the dialogue they're hearing. Human nature, and maybe I'm a cynic, but human nature says, they're going to say, wait a minute. I'm going to go for the lowest charge there and leave it to some jury to deal with this. Why do I need this in my life, okay? Why isn't, especially if they're coming home watching the TV every night, they're seeing the pictures playing out, the neighbors are all asking the questions, why isn't that more likely than not, given that they're consuming everything that we've consumed for the last 3 months?
Look, human nature being what it is, obviously you're making a very good point, because this is a case that's a high-profile case. Undoubtedly, there's going to be a lot of pressure, subliminal or otherwise, on the grand juries to, quote, do the right thing. They live in the community. They work in the community. They've got to sort of justify their verdict, or they're going to be held accountable for their decision by their neighbors and by the community. What the district attorney has said he's going to do, and if he does it, it's a smart thing, is he basically has said that what he's going to do is he's going to petition the court to unseal the entire grand jury record. So that basically, since a grand jury is a secret proceeding, whatever the community will be able to judge for itself how fair a presentation he made, and whether he did, as you suspect many prosecutors do, sort of tell the grand jury what they want the grand jury to do. In this case, if the DA did the right thing, and he said he was going to do it, present all the evidence, instruct the grand jury, and let the grand jury make its decision on its own.
And just to further complicate it, because of course it's so simple right now, you also have the potential of the Justice Department getting involved in this, and they may not want this thing unsealed here, depending on what comes down or doesn't come down tonight. All right, we're going to take a very quick commercial break. We're going to talk about much more of this. We'll also probably hear from the Missouri governor on the other side of the break as well. We'll continue this conversation straight ahead.